It's your boy Blizzy the Don, and we back. We doing something a little different today. So today we're gonna be going over court documents and how the child support um department actually committed a bunch of fraudulent activity. So bang, gotta be careful about the information on this document. So first and foremost, I do for my kids. Let's get that understood. The mother of my son says she needs more help than what I already offer her. Okay. Um, so she goes to the child support court or whatever the hell, the Department of Human Services, and essentially files for child support. They let her know the steps she has to take. First, I have to do a DNA test, which is completely voluntary, and I did not know that. Oh, man. All right, but yeah, she sends a so they say I got to do a DNA test, paternity test. So they send an order. They send an order in the mail. It says her name versus Xavier Taylor. That's not me. But let's read what the order says. You are hereby ordered pursuant TCA 365802 along with Salakia, along the above named children to appear and submit to testing for paternity determination as directed below. It gives a date, time, location, address. Two forms of identification, like it, two forms of identification must be brought to the appointment. At least one must have your picture, such as a driver's license. Mind you, this is for Xavier Taylor. It says you may appeal this administrative order by filing a written request for an administrative hearing with the child support office shown below, Salakia, shown above within 15 calendar days of the mailing date of this order. The only grounds for appealing this order are a mistake of identity, a mistake of fact, or that it was issued in an arbit arbitrary or capricious manner. It is further ordered. I'm reading slow on purpose. I can't read already, but I'm still reading slow on purpose. It is further ordered that the parties complete their required information found in Exhibit A to this order. You must provide the information immediately to the local child support office listed above. Additionally, you are required to notify the child support office listed in Exhibit A of any changes in information on Exhibit A within 10 days of the change. Failure to obey this administrative order may result in the imposition of fine and or imprisonment for contempt or suspension of your driver's license or other license. If you have any questions concerning this administrative order, you should contact the child support office. So, like the child support office at the above address. Enter this 24th day of October 2024. The Title 4D administrator signed right there slash supervisory designee. And then it says, I think I can show y'all this one. Nah, I still got her name. I ain't gonna do it like that. Certificate of service. I hereby certify that a copy of this order was served on Xavier Taylor, her name, and the clerk of the juvenile court of Rutherford County by mailing to him slash her by first class U.S. mail, postage prepaid on the 24th of October 2024. Once again, signed by the Title 4D administrator. So, bang, get the document, see it, not knowing that there is a difference between a judicial order and an administrative order. Look, I got this ice cream and cake, y'all. I gotta mix this up. I didn't know it was a difference between a judicial order. I mean, I did actually. I lied. I just lied to y'all. But I assumed that this was a judicial order. Threatening imprisonment, threatening my driver's license, a fine. I'm assuming that. Okay. But yeah, I'll get that definition for you. Pull it up. Actually, in 2 seconds. I'm gonna show y'all something. So, and keep in mind, they also told me I have 15 days to respond. But they spelled my name wrong. Who the fuck is Xavier Taylor? It's crazy. Hold on, printing something out, y'all. Turn the printer on. Why the fuck is my printer not turning on? So like yeah. More technical difficulties. And I just spit. Fuck. There you go, y'all. Ah. Got something to do with my filing cabinet. So like yeah. Too much bullshit going on. Bull, 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 bull. Mm-hmm. Damn, come on, bro. All right, there we go. Printing this out right now, y'all. So bow. And then that's printing. Motherfucker tripping. It's hot in here. So boom. Judicial order versus administrative order. Legal distinctions. A judicial order originates from a court of law signed by a judge and results from proper legal proceedings where both parties are giving notice and a chance to be heard. An administrative order is issued by an agency, not a court, and lacks jurisdiction authority unless formally adopted and signed by a judge after proper legal process. So that document telling me that I have to go do something had no jurisdiction. It was completely voluntary. But the way they used it, threatening my freedom, I was under duress. I went to do it under duress. I went to do it under duress, not knowing that it wasn't a judicial order because I didn't deal with orders before, and I'm just simply thinking that it's an order, so I gotta go do it. I'm thinking I'm obligated to go do something when I'm not. Bro, it's cat hair. I got cats and shit. Thinking I'm obligated to do something when I'm not because it's not a judicial order. If a judge had signed off on this, I would have been obligated to do so. Since there was no judge that signed off on this, I wasn't obligated to do so. Okay, so they sent that. I think they sent it. Where they entered it the 24th of October. I don't know when I got it. Oh, that's what it was. So I went in there. When I went in there, you know, thinking I had to do this or I was gonna go to jail. I went in there. Take out through the day. Um, my wife, my fiance, and my daughter were outside waiting on me, and they wanted to know how everything was gonna go. So they was riding around, walking around, just wasting time. Never knew they never did this before. I never did it before. We didn't know how long it was gonna take. So we're just stalling time. I go in there. I'm there before my son and his mom. Do what I had to do, fill out whatever paperwork. I don't even know what I filled out, but I know when she did arrive, is when I was holding my son. They asked us. They asked me to come in there, and they went ahead and mouth swabbed me and him. Right? Yeah, mouth swabbed us too, and I guess they mouth swabbed her. I told her my name was spelled incorrectly, and they used whiteout, and she fixed it or whatever with whiteout, and I was like, that's all. Like, she was like, don't need to do like you don't need to do nothing. Oh no no no, you good and this good and da da da. But they was you could tell that some like they was confused. Like, oh damn, not this shit again. Like, cause I'm no genius, but I know my right to due process. Let them fuck it up though. Um, to my knowledge, whiteout is not no. You cannot just use whiteout on a name. Maybe the DNA test, but not the order. So okay, cool. They use whiteout. Um, It was a violation of due process essentially. Um, if they updated the name, my name, my legal name, my strawman on that case, I have not been reserved. I have not been served. I haven't been served in the first. The only thing I have gotten in the mail was that first order, that first administrative order posing as a judicial order saying that I got to come take this paternity test to Xavier Taylor. Only thing I received. So after that, I never received any other mail. I didn't know that I had a court date. The mother of my child was playing and she damn near didn't want to tell me when it was. She was like, maybe you should check your mail. I did. I don't have anything in there. Oh, well, maybe you should just Eve being Eve. So cool. Bang. Times passed by. I called them eventually and I asked them like, "Hey, do I got a court date?" Yeah, it's this day, May 1st. Whoa, May 1st. Okay. I'm like, why haven't I been sent anything in the mail? Mind you, I called them. Let's see when I called them. I recorded the call because they call said it's being monitored and recorded. So mine is too. Let's see. Yes. And I'm trying to get my number placed on the do not call list. Okay, that's not it. This is it. I haven't received my paternity test in the mail. They told me that they had the correct address, just the wrong unit number or something like that. So I updated it about 2 to 3 weeks ago and still have not received anything in the mail. Trying to let y'all hear it without me having to hold it. So I go on mute right there because like they got me on hold.
Okay, so it looks like you talked to a caseworker, um, and she let you know that um, we tried to serve you, but we had the wrong apartment number.
That's what I just
They're
told you.
not going to try to reserve you again.
I
Because
haven't
the
got. It's not
turnaround
the
time would
serving.
be.
I'm not talking about just the serving. I haven't got my paternity test in the mail.
Well, if we haven't received it back, we couldn't resend it back out. As far as
It
I
was
know, I don't
received.
see
She's
it.
told me. The mother has told me that it was received.
Well, hers has, but not yours.
That's
I
what
mean, yours would have to be returned to us because it wasn't at the right address and then sent back out.
So the 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 results are not
Have not
documented.
been received back to
Right.
us from them trying to go out to get to Europe.
Understood that. So what I was trying to say before you cut me off is what I'm saying is so the results are not elsewhere. Those were the only results. The ones that you all sent out are the only results of my DNA paternity test from me and my son. That was the only one.
She would get her copy, and then there would be a copy sent to you. But they're not going to make another copy and send it back out. They're going to wait for those to be returned.
Yeah, and I was told by the lady previously that everything that was sent in the mail was returned. Everything. She said everything y'all sent me, it kept getting returned back to us. Literally. And then when she told me when I updated my address, I gave her my unit number.
Reading the notes.
Okay,
that you had the wrong, that we had the wrong apartment number, and you wanted the summons sent back out. So then she got the correct information, but the court date and time,
so
or the turnaround time wasn't there.
So how would I? What? Court is next month. That's more than enough time for a document to be sent back. I called before this month started.
No, that's not how it works.
It's very much okay. No, you got it. I'm listening to you.
No, you tell me how it works.
I'm listening to you. I don't know how it works at all. I'm just a civilian. You work in the child support area, so I'm asking you, how does it work? What the turnaround time wasn't enough time?
So the summons, if it's returned because we didn't have a good address, it has to be processed again. It has to go to the clerk's office and come back through again. An alias summons has to be done.
And what was the name on that actually? Did you all update that name?
What name?
What was the name on the whole case? There was an incorrect name. I just wanted to make sure that got updated. As far as my name,
it's the same name that you gave me when you called. You gave me your name.
You said when I gave you. Oh, right. So that's the name. So it got
that's
updated.
The name on the case.
It wasn't at first when we first walked in there. That's what I'm stating. I just want to make sure everything else is up to T. Since
yes.
So what is the return time? I'm asking you. You said a month is not enough. It has to be reprocessed before it could get resent out as far as the summons.
Well, it just depends on how long it takes to get that summons back. They've got to process it through legal. It's got to go to the court and then come back. So by the time our process server gets out, it would be past the service time, which is a 10-day window.
10 days. So, and the court date is when? Because I don't know, because I don't have a piece of paper. The court date is May 1st.
Oh, you've been told when the court date is. You just told me that we had told you when the court date was.
Yeah, May.
May 1st.
Everything she's saying is not due process. It's not due process. I have not been served. I don't know what the fucking address is. Like, she's saying all the wrong shit. Like, all the wrong shit. But yeah. And they tried to say, like, so when I reached out and I filed an affidavit, I'm gonna tell you all the things I filed. I filed a notice of an administrative objection and response to the administrative order. It says Xavier Alexander Jackson, am submitting this formal notice of administrative objection and response in reference to the administrative order issued on or around October 24th, 2024 under the name Xavier Taylor. The administrative order is defective for the following reason. The name used on the order, Xavier Taylor, is not my legal name. As such, I was never lawfully identified or served under my correct legal identity. Upon appearing at the paternity office, I was corrected. Salakia, I corrected the error in person, and the staff altered the document using whiteout to reflect my proper name, Xavier Alexander Jackson. Despite the correction, I was never reserved under the correct name. 2. The administrative order was not issued by a judge and does not constitute a judicial summons. It was delivered via first class mail and not through any method that satisfies proper legal service under Tennessee rules of civil procedures. I was not informed, no, 3, I was not informed that compliance with the order specifically regarding the paternity test was voluntary, and that the order did not originate from a court of law. My participation was based on misinformation and assumption of legal obligation, not voluntary consent. 4. I have received no verified claim, sworn affidavit, or signed complaints from the alleged claimant, her name, my son's mother's name. Without a verified claim or contract, there is no enforceable obligation. Therefore, I object to this Salakia. I object to this administrative order and any further actions taken under it. I reserve all rights to challenge the validity of this administrative proceeding, and I demand that no further enforcement actions be initiated until proper service, lawful jurisdiction, and verified claims are presented on the record. Respectfully submitted on the 18th day of April 2025. Xavier Alexander Jackson signed. Sent that. Then I sent an affidavit of truth to the juvenile court for Rutherford County, Tennessee. I, Xavier Alexander Jackson, a living man and respondent in the above captioned matter, hereby submit this affidavit of truth and affirm the following factual statements under penalty of perjury. This affidavit is made off my own free will with no intent to mislead and is based on first-hand knowledge and experience. 1. The order issued in this case was administrative, not judicial, and no lawful judge presided over any hearing or entered any ruling in this matter. 2. I was coerced into taking a paternity test that was labeled voluntary, but was in fact taken under duress after being threatened with litigation. 3. The name used in this case, Xavier Taylor, is not my legal name. My full legal name is Xavier Alexander Jackson. 4. I was never lawfully served with any summons or petition as required by law. No personal service occurred at my correct residence, and I only became aware of this case through informal means. 5. I have never received certified or official paternity results regarding this case. 6. The original filings or orders were physically altered using whiteout to correct the spelling of my name, which invalidates the integrity of the court record. Let it be known that all claims made herein stand as truth unless rebutted point for point by sworn affidavit within 30 days from the receipt of this notice. Failure to rebut constitutes agreement and admission of the facts stated herein. Signed by the affiant Xavier Alexander Jackson, 4/18/2025, and notarized by Cameron Cruz, State of Tennessee Notary Public, Williamson County, 11/15/2025. About that. Power of attorney. Limited. Know all men by these presents that I, Jackson Alexander Xavier, the debtor, corporate entity, and ens legis, the undersigned, hereby make, constitute, and appoint Xavier Alexander Jackson herein, the flesh and blood man, a living soul, the secured party creditor, as my true and lawful attorney in fact for me and in my corporate capacity, LLC, place and stead for my personal and commercial use of benefit. 1. To ask, demand, request, file, sue, recover, register, collect, and receive each and every sum of money, credit, account legacy, bequest, interest, dividend, annuity, and demand, which now is or hereafter shall become due, owing or payable or dischargeable, belonging to or accepted or claimed by me, or presented to the debtor, Jackson Alexander Xavier, in all capital letters. A corporate entity, to use and take any lawful and or commercial means necessary for the recovery thereof by legal or commercial process or otherwise, and to execute and deliver or receive a satisfaction or release therefore, together with the right and power to settle, compromise, compound, and or discharge, set off any claim or initiate any administrative claim for damages or make any necessary demands. It's a power of attorney. It's more brain for Rito, that bro. I ain't gonna tell you. There's another thing I found. And also, they told me that my address that they had, I mean, I heard in the audio, it's more. They said the address was wrong. I received the order, though. The order telling me I had to show up to take a paternity test. I received that. But I didn't receive anything else. My address was wrong, but I received anything from y'all, period. Make it make sense. So you telling me I received one thing, but the paternity test I don't receive, and you say it's been a turnaround, and since y'all sent the results out, the turnaround has been like, when was this? You know, it's a bunch of questions. It's a bunch of questions, but okay, cool. So to kill all that, we filed a notice, updated mailing address. Comes now, Xavier Jackson, a living man in proprietary persona, and hereby notifies the court and all relevant agencies or parties that effectively, immediately, all future legal corresponding documents, notices, and service of process shall be directed to the following address: my P.O. Box, which if y'all want to send something, be my guest. P.O. Box 111233, Nashville, Tennessee, 37222. Shoot me something. This address shall, as my designated Salaki, This address shall serve as my designated and proper mailing address for all matters pertaining to the above referenced case unless otherwise amended in writing. Respectfully submitted the 23rd day of April 2025, Xavier Jackson, in propria persona, not pro se. I hereby, that's like it, certification of service. I certify that a true copy, so like it, that a true and correct copy of the foregoing notice of updated mailing address was served upon Naya Simone Woodson via U.S. mail and to the Child Support Services 20, well, yeah, that address. Bang. About that. I also filed a request for discovery. Because how we gonna move forward if I don't even got the case file? I don't got nothing. I don't got nothing. I don't got nothing. Like nothing. Like only my granny, man. Only my granny. When they see this, only my granny. My own liver. You know? Only my granny, man. Only that beaut. That beautiful. That beautiful beaut. Only my granny. So yeah though, like how we gonna move forward, Pete? I ain't got no documents, you did. Fuck you, man. So how we gonna do that? That's a request for discovery. Wow. And furthermore, I get a response from the state saying that I passed the date. Oh, lack of better terms, you didn't respond in 15 days. Uh-huh. Let's see. Let's read it. Dear Xavier A. Jackson, your request for an administrative hearing has been received. The Child Support Office took action on November 13th, 2024, and the appeal was filed on April 23rd, 2025. TCA 365-1001 sets forth the authority which governs the appeal of the administrative actions by the Department of Humane Service relative to Title 4D Child Support Services. This section provides that the person seeking an administrative hearing shall file within 15 calendar days of the date of the notice of the administrative action. As a written appeal was not timely filed, this request cannot be accepted. So like, an appeal is filed on the date and is received in writing by the department or the local child support services. If your written appeal was filed on a date earlier than the specified above, or you think you have good cause for people, they say they said if your written appeal was filed on the day earlier than that specified above, or you think you have good cause for not timely filing your appeal, you may file a good cause request with supporting affidavits with the commissioner's designee for appeals, division of appeals and hearings as followed by the state rules, like your rule at the following address, and it gives me an address. I didn't ask for an appeal. I didn't ask for an appeal. I'm not asking for an appeal. I'm not asking for an appeal. But I responded to him though. Hit back. Hit back real quick. My response, it says, notice to clarify. Boom. Okay, boom. The rebuttal. Rebuttal. We respond. This us responding to them. Rebuttal to appeal resolution and objection to findings. To whom it may concern, this correspondence serves as a formal rebuttal and objection to the appeal resolution letter dated April 28, 2025. I respectfully assert the following. 1. I did not file an administrative hearing request. The letter indicates that I filed a request for an administrative hearing on April 23, 2025, I did not initiate such a request. And there's no evidence of my submission or signed acknowledgement. If a request was processed in my name, it was done in error or without my consent. Number two, the 15-day deadline does not apply due to material error. So when they said, do you have good, what they say? Good what? Good cause, quote unquote. Um, the 15-day response deadline does not apply due to material error. The administrative order issued on or around October 24th, 2024 incorrectly named me as Xavier Taylor. That is not my legal name, and I notified the agency of an error in person. That correction was made with whiteout rather than a proper reassurance and reservice under the correct name. I never got served. I like never got served, like never, like at all, under the false name, under the real name, under the updated name. I only got an order saying, "Come get this DNA test, boy." That's it. That's all. According to this, oh look, this one they fucking with somebody. They fucking with. Okay, look. According to Tennessee Rule of Civil Procedures 4.01 and 4.03, service must be properly executed upon the correct individual. If the named party is not the same as the respondent, the service is invalid and fails to confer jurisdiction. Additionally, under TCA 36.5 1001B and TCA 36.5 405A, an administrative order that is not properly served or contains an error of identity is void or voidable. The 15-day appeal deadline cannot begin until proper service is completed to the correct party. See State versus Chapman, 977 SW 2D 122, Tennessee Criminal Appeals, 1997, which the court held that, quote, due process requires notice reasonable. Salakia. My fault, G body. Due process requires notice reasonably calculated to apprise interested parties of the pendency of the action. Unquote. A misidentified party cannot reasonably expect to meet statutory deadlines for an appeal. 3. I request formal correction and dismissal of the administrative order. Given the above, I respectfully demand that the order and its enforcements, it's like enforcement mechanisms be withdrawn, and that the administrative process be either dismissed or restarted under proper procedural safe grounds with correct identification. Respectfully, Xavier Jackson. Something else when they ask. Notice to clarify filing intentions. This notice is submitted to clarify the intent and content of the filing previously submitted by me, Xavier Jackson, in relation to the administrative order dated 2024 October 24th regarding case number. Yeah, at no point did I request or intend to request an administrative hearing. My filing, specifically the notice of administrative order and supporting documents, were submitted as formal objections and jurisdictional challenges, not as an appeal or hearing request under TCA 365 1001. The purpose of those filings was to 1. Object to the improper naming of the respondent as Xavier Taylor, which is not my legal name. 2. Challenge the validity of the administrative order due to the material errors and lack of due process. 3. Reserve all rights under state and federal law without consenting to administrative jurisdiction. As such, I respectfully request that no administrative hearing be scheduled and assume, based on the above filings, that my documents be entered into the record solely as formal objections. If any clarification is needed regarding the nature or intent of my filings, I am available to respond in writing upon request. Respectfully, Xavier. That's how we coming, bro. So I don't know who the fuck they think they fucking with, but the right one, bro. Like they really got him. They really got him. Um, and I'm here for it, bro. I got a bunch of case law proving certain things. BM think it's personal. It's not personal, baby. You did the dumbest shit in the world, and you filed a child support case when I actually take care of my son. The amount of money I give her, bro, I just gave her $100 to go on a date with another dude. I support her. Fuck. I fill up her gas. I filled up her gas multiple times. Fuck. Like, and that's like, I don't give a fuck. That's some real nigga shit. That's just me though. Like, that's just me. So like, bro, she breastfeeds. She don't gotta pay for milk. That's the biggest expense. The fuck? It's so much shit, gang. She live with her mama. What is she paying for? She don't pay no bills. Baby go to school. And I commend her for that. But what we not gonna do is say I don't take care of my kids. Then I tell her we can settle outside of court. She says the amount that I'm giving her right now, she says $122 more than what that is. What I already give her right now. And nah. I'm disabled. I'm legally disabled. I work, gang. I work. I can only work up to like 4, 5, 6 hours a day. Like I gotta work part time cause I'm disabled. I live at home with my like I take care of all my kids. First and foremost, I can show y'all countless pictures and videos of my children, gang. Countless. I got my son every weekend. Every weekend, and she say I'm a deadbeat. She say that's not enough. You're a weekend dad. Like you can't satisfy the bitch. Can't satisfy the bitch, gang. So don't try to satisfy the bitch. And I'm not even talking about her. I'm talking about, hey, you. Do not chase no bitch, gang. And don't satisfy the bitch, bro. You are the man, bro. Put your motherfucking foot down and stand on your 10. If the bitch want to take you to court, fight the bitch in court. And I'm not talking about my BM. I'm talking about in general. When it come to this shit, bro, you gotta stand for something or fall for anything. We ain't falling. So I'm gonna let y'all know how this go. It's your boy Blizzard the motherfucking Don, boy. And we back like cook crack, nigga. Long live my granny, man. You know how we coming, man. I'm gonna keep y'all updated with this shit, man. You know, bitch. Money hungry, free shooter, free Diddy, free Ken Ken, long live Terry, nigga. Bitch. You know how we coming, nigga. Gang shit, no lane shit. Fuck the ops, nigga. And yeah, it is what it is, nigga. If you got a problem, if you don't like